What's up, everybody? This is your boy King L Bay, dropping this knowledge on y'all today, right? Dropping this knowledge on y'all today, family. What's up? What's up? What's up? I'm discussing the master class as relates to the master class, family. What's happening? What's happening? You feel me? We're going to get into some discussion. We're going to talk about treaties. We're going to talk about all of this stuff, how it relates to, how all this stuff relates to wars and what we need to be doing, man. Come and check this out. We need to get on this and get this popping, family. What's up? What's up? So I'm gonna drop this information into y'all lap, and we're gonna get into some good specifics. Let me see, which one is it? Let me mute this. Let me get this into. I got an echo. I'm trying to drop the echo. What the echo? I got an echo. I'm trying to drop the echo. Let me drop the echo, right? So let's get into this, family. And we're going to talk about this because it's very important to understand estate planning from the international level to the domestic level, to understanding it in these degrees as it relates to this. So I'm just dropping some information on y'all so y'all can start understanding. I think the community, it's a lot of people who are in this, right? And they're trying to get reparations, compensation. We're trying to get our liberation, but I think we must understand the context of what we're doing to ensure the integrity of the process. And it's just too many people who haven't had the experience. They don't have the litigation experience needed to perform certain things and do certain things to a certain level or degree, right? To a certain level or degree to ensure that this stuff can get done, because a lot of people don't understand this information, man. So what we're going to talk about, this is what I bring with the masterclass and understanding from private banking to understanding this stuff on a domestic and international level. When we're talking about private rights and private rights of actions, being a foreign national as it relates to the jurisdiction that we're dealing in, right? So we got to get this together, right? So that I can break this stuff down for y'all. So let's get into it. So King L Bay, let's relate to treaties. How does this stuff work? How does this stuff work as it relates to treaty, family? How do it work? Tell me the insight. First of all, you have to understand how to read a contract. The contracts are tailored. There's no happenstance in contracts. You can't just say, oh, this just happened. No. People have what they call a contractual intent on the basis of why they wrote what they wrote. through their expression to interpret the rights of each party. So it's all done through contract. Rights are done through contracts. This is what makes us civil. The civility, and civil nature of things, making us civilized, right? So I want to show y'all something as it relates to the treaty. I'm ready for y'all to comment and ask questions. You can comment and ask questions, and I'm gonna break all of this stuff down because it's just too many of us not knowing. So let's go over the doctrine of incorporation. Hold on, let me share my screen. I didn't share it. Let me go back and share the screen, family. Let me share the screen. Share the screen. This is it's levels to this, family. It's levels. So let's go here. We're gonna talk about it on the international scale. What has what has come to be known as the doctrine of incorporation is taken to state that customary law is automatically a part of the law of England and Wales without the need for legislative intervention. On this rules of customary international law is ipso facto rules of common law. Let's go to the ipso facto rules of common law. Like, ain't nobody talking about this ipso facto rule. Ipso facto clause allows a party to an agreement to terminate this agreement unilaterally, or the agreement in question may even be terminated. Remember, I talk about the operation of law. By operation of law, due to bankruptcy, other insolvency related situations, such as an offering of compensation to creditors or to the poor financial condition of another. Ipso facto prohibition in corporate acts applicable to corporate insolvency, right? Ipso facto clause is contractual provision that allows one party to a contract to terminate or modify the operation of the contract upon occurrence of a specified insolvency related event, such as appointment of administrators, receiver, or liquidator in respect of another party. Example include a clause that it entitles a landlord to terminate a lease in the event that the administrator is appointed to the tenant, and a right to terminate arises under a loan agreement caused by the borrower making a court application in relation to a proposed creditor scheme of arrangements. So, a lot of y'all, when y'all go purchase cars and y'all go purchase things, y'all need to understand, like when you buy a house, you become a tenant. If you go from the purchaser to a tenant, and the bank has granted you the rights to occupancy. A lot of y'all don't read y'all contracts. When you go buy a car, right, you become the what? The leasee. They the leaseor. The bank becomes the leaseor until it's paid off. But you got to understand all the things associated with these rights. A lot of y'all think that y'all own this, like the money, that my money in the bank. No, you only have a right to use, the right of use. Let's look up the right of use. Social Security card, the right of use. Listen, legal definition of right of use: a personal servitude conferring a specified use of an estate that is less than full enjoyment. You only have the right of use. This is why they can take your car, they can seize the money. Like if you was they can put a freeze on your bank account, right? Let's say you owe the IRS, let's say you was selling drugs. They can freeze your money. Why? Because you technically never owned it. You only have what they call the right of use. And through that, because that is somebody else's intellectual property that is a part of their estate. This is all estate planning. I don't care if you go on an international level with treaties, all of these things, these contracts are property. Why are contracts property? Because these things become property of the estates and it verifies rights of the original parties. Without the contract, you cannot make certain determinations. So, when you have a contract, that contract has equal footing to the same as the property itself. It's on equal footing because that becomes property because the contract make a determination of the rights associated to the real or physical property. You feel me? So a lot of us don't understand the right of use. We don't understand these contractual things, so we get stuck in this realm of not knowing. This realm of not knowing. This realm of not knowing. So let's get into the treaties to discuss how treaties, Morris treaties, are a part of the United States domestic law. Now we're going to go to the statutes of large. Let's go to the statutes of large. Let me see what I do with the statutes of. So the Treaty of Peace and Friendship is a part of, right, statutes of large, right. We can go to the supremacy clause of the Constitution. Also, let's go to the supremacy clause of the Constitution. The supremacy clause of the Constitution established that constitutional federal law made pursuant to it and treaties made under its authority constitute the supreme law of the land and thus take priority over any conflicting state law. Let's read this again. The supremacy clause of the Constitution of the United States established that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land, and thus take priority over any conflicting state law. So invoking your treaty rights, right? But you must incorporate your treaty rights the right way. And then you must appropriate your rights associated to property. So a lot of Moors, what the problem is, they think that just because they are Moor, they can now just assume, right, things and do things, and it's it's in conflict, right? That they just assume, right, that they have a priority or they automatically have certain rights due to certain property. But here's the problem: they misappropriate the law because most of the property that we're dealing with is not our property. So, in the treaties, right, treaties cover certain things in relationship to property. But if you understand treaty law, right, let's go here. We're going to talk about crimes, right? We're going to talk about privileges, how we're going to go through this. We're going to talk about crimes, duration of treaty. We're going to go to the crimes, right? Now this is under the Treaty of Peace and Friendship. Let's go to the Treaty of Tripoli. Let me see now. Let's go back to the Treaty of Peace and Friendship, and we're going to talk about how crimes, how where it talks about crimes, right? Where more kill, how crimes shall be punished, right? It says if a citizen of the United States kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the contrary shall take place, and equal justice shall be rendered. The counsel assisting at trial, and if a delinquent shall make his escape, the counsel shall not be answerable for him in any manner whatsoever. Right? So, what what you have to understand, right? This is a part of domestic federal law. This right here. This is a part of original jurisdiction arguing the claim. Because a lot of y'all are arguing different things. Y'all are arguing diversity of citizenship and all of this diversity jurisdiction. And y'all arguing diversity of jurisdiction as if you are a citizen. In proper venue, you automatically gonna get your case kicked out. So how crime should be punished, right? And they got it in the Treaty of Tripoli. Let's go to the Treaty of Tripoli, right? And I like this because it has the footnotes, right? And you have to understand this stuff as it relates to this. This is perpetual, right? To everything. And we're going to talk about protected classes as it relates to this proper passport. Trying to remember with both parts. Proper passports to be given, okay. A citizen of either party have brought prize vessels, bill, okay. Vessels, supplies. Should a vessel either be a part of this? If a vessel should be attacked by the enemy gun, right? So a lot of this stuff as it relates to perpetual peace and friendships are acknowledged have received, right? So what y'all got to look at as it relates to crimes, right, and treaties, right? So as it relates to this criminal matter, what happens is there there are supplemental law that is embedded into this, right? So one of the problems is like Moors think that everything is theirs and that the treaty applies in particular circumstances. Like, nah, man, we right automatically have particular rights as it relates to treaty benefits, and it don't and they specify certain particular individuals who shall enjoy certain things. So let's go to Article 9. And I'm going to talk about that as it relates to this Article 9. So you can understand as a subject. See, if you're a foreign subject, you don't have the certain protections of particular individuals. So, as a foreign subject, you are subjected to the laws, the domestic laws of that nation. So, what happens is you go in there and start arguing Moorish treaties, and you're dealing with that domestic product or property of that nation, and you're not protected under having a particular status. You're not protected. So you don't enjoy the full protection of every piece of the treaty. And we'll get into that. I don't like in the master classes, we're gonna get into that. I want to show you certain particulars in this video. I don't want to make these videos super, super long. So let's go. It says commerce between the United States and the Tripoli, the protection to be given to merchants. The protection shall be given to merchants, masters of vessels and seamen, masters of vessels and seamen. The reciprocal right of establishing counsel in each country and privilege, immunities, and jurisdictions shall be enjoyed by such councils are declared to be on the same footing as those of the most favorable nation, respectively. So you got to understand this because this is very important as it relates to treaty and interpretation of law, as it relates to treaty, right? Only particular individuals get to interpret treaties. So let's go to most favored nation. Most favored nation is best used to describe the treatment given to a particular individual it is a form of protection according to a single counterpart to assure them that no similar situation counterparty is getting a better them than they are. So when we talking about the most favorite nation, right? Most favorable nation clause require a country to provide any concession, privilege, or immunities granted to one nation in a trade agreement to another World Trade Organization country, although its name implies favoritism towards another nation, it denotes equal treatment of all countries. So, when they wrote the Constitution, equal protection, due process, all of this stuff is embedded from the treaties. When they wrote these constitution, they had to keep in mind the treaties. It's not no coincidence that due process and the equal protection clause, because the treaties gave them a grant to exercise their jurisdiction. So they had to keep in mind these particulars when forming their constitution. You have to understand this, family, as it relates to this information. You have to understand this information as it relates to this when you're dealing with the particular stuff as it relates to treaty and treaty benefits. This is a part of treaty benefits that need to be discussed, right? So let's get more into the treaties. So we're going to talk about, this is why I say more should be industrial, right? This is why I talk about a master trust, master of a vessel. So what do that mean as a master of a vessel? Master of a ship is an employer of the owner of a ship. Accordingly, the owner of a ship is vicariously liable for the acts of a master in the course of his or her employment. For insurance purposes, this means that the owner of a ship is liable for proper loss, personal injury, or death resulting from negligence of a master, whether pursuant to. So, when we talk about a master trust, it it can be in the form of a vessel. That means the individual authorized to represent the vessel on behalf of the buyer. So when we talk about a master trust, as it relates to insurance, as it relates to status, as it relates to everything you're trying to do, right? Because what you have to understand is this, family. What you have to understand this information as it relates to contract law, right? Why it's not? Let me go here. Why it's not? Where did it go? Let me see. Where did it go? Let me see. Let me go. Let me see. Do I want to do that one? So we're gonna go here. Who are to be protected? Protected class, merchants are protected under the United States. They have consumer protection laws. But those, when you claim that you are a consumer, you just invoke jurisdiction because you are using that particular protected class, taking on a privilege and a benefit of the United States to get yourself a remedy. So all you Moors who keep trying to invoke these consumer protection laws, you just stripped yourself of your status as it relates to certain things. You can't have it both ways. You can't serve two masters. So if you create a master trust, you have to serve the master trust and its responsibilities and duties. You cannot serve two masters. And this is the problem, is because we cannot identify, and since Moors do not make nothing, we don't make our own cars, we don't really make our own food, we don't really make our own clothes, we don't really make our own planes, boats, trains, hospitals, medicine, all of this, since we don't make too much of anything, right? What happens is that we're subject to that individual because these are their products, goods, and services in which now you have took into your possession and you're at the mercy under their authority because y'all don't understand that the law follow the property. So y'all keep going through this same old King L Bay, King L Bay. King L Bay dropping this knowledge on your head so you can understand what to do with this information. So you will know how to move and properly litigate. That's the problem. Y'all don't know how to litigate. Y'all don't know how to look at the law and learn how to litigate. Y'all don't understand what to do with this information, so you don't know how to litigate. You don't know how to look at it and understand what your status should be as a Moor. So the treaties, if you adopt the treaties and you're a particular class or a particular individual, you're automatically deemed a protected person under international law with the United States. Gotta get that little fly. Shit. So let's get back into treaty rights. Let's understand estate planning on a level. So when you understand that everything is property, now you can associate what property goes with what, and the law follow the property. So now stop getting confused thinking that you own something when you don't own it, because what's going to show you is the paperwork is going to determine the ownership. And when you don't own something, right, what's going to happen is you're going to find out the laws associated with that. This is why when you incorporate an LLC and all of these different things, you are now incorporating under that jurisdiction in which the state or the federal government have a jurisdiction. So, like when you incorporate within the state and you start dealing in interstate commerce, what one of the problem is that they always hitting you with these interference or interstate commerce charge or interstate or intrastate commerce. They don't really tell you you are interfering with commerce. Y'all got to understand this information, family, so you can stop being a victim, because it's a lot of disingenuous information as it relates to treaties. So let's look at how estates of deceased citizens shall be disposed of. It says, if an American citizen shall die in our country and no will shall appear, the council shall take possession of his effects. And if there shall be no council, the effects shall be deposited in his hands of some person worthy of trust until the party shall appear who has the right to demand them. But if there but if the heir of the person deceased be present, the property shall be delivered to him without interruption. And if his will shall appear, the property shall descend agreeably to the will as soon as the council shall declare the validity thereof. Reason why I talk about the will is the most important document. It keep you connected to the treaties. It keep you connected with your lineage, and it keep you connected to your property rights. Everybody want to talk about a trust, but y'all skip over the damn will. Like the trust, a trust is nothing but a relationship. You can create a contract, and the contract can establish a trust relationship. It can be spelled out in the contract. The piece of treaty and the treaty and piece of friendship is the highest form of trust. This is a this is a trust. Like it or not, this is a trust relationship. And what they do is they use words. right? To um, they use these words to conflict confusion, to keep you confused about the pieces on the board. They use words to keep you confused so you can't not verify what's what. Treaties are a form of trust. They are property. I want y'all to understand contracts are property. Look at everything as property. And if you look at everything as property, then you can make a determination of everything because the law followed the property. Then you will know what law apply to the property, especially if it's not your property. And if you know how to read the contract and interpret the contract because you in a capacity to contract. And if you're in a capacity to contract, that means you have the right to interpret the contract. So I talk about all of this stuff in the master class. We representments and presentments. Y'all need to understand this stuff as degrees of level. So it's a lot of people out there that's disingenuous with this information and what they're doing with this information, they're not helping you evolve and you're stuck and you don't know what to do. So this is King L Bay. I'm trying to see how long is this video. No. So we're gonna answer the Moore's question. We're gonna answer, like I said, it's a lot of disingenuous information with the secure party creditor process. I'm not saying that it's not useful or don't. It's not. It's not helpful. But we gonna break it down to every degree of estate planning because that's all it is. It's estate planning. When we talking about this global nation, we talking about estate planning, and we talking about rights. We talking about treaties. We talking about international law as it relates to contracts. That's all it is. Everything a contract forms a trust relationship. Everything is trust as it relates to contract law. What you got to understand that a contract is based upon what it is. If you understand these terminologies, it's about trust. If I give you, me being a merchant, and I give you 100 of my product, my invention, boom, 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 I'm trusting you to pay me. It's a trust relationship. So treaties, contracts, all of this stuff falls under trust law. What makes something binding is how it is written, if there is not any discrepancies, and if you have the capacity to contract. This is what the age of majority is all about. So this is King L Bay sharing the masterclass. Peace and love, everybody. I'm dropping this knowledge on y'all so y'all can get it. Like I said, there's too much disingenuous information out there, and I'm gonna be able to bring it once you understand the operations of law. You understand? I showed y'all in this everything that I do. I showed you in the paperwork. I showed you under this stuff under the operation of law. So let's just go to operation of law as it relates to meaning. Operation of law means a transfer by inheritance, device, or bequest, court order, dissolution decree, order in bankruptcy, insolvency, reprieving, foreclosure, execution, executive sale, the execution of judgment, the foreclosure, the foreclosure of real estate mortgages, the forfeiture of real estate contracts, a transfer resulting from a decree for a specific performance. The phrase operational law is a legal term that indicates the right or liability has been created for a party irrespective of the intent of the of that party because it is dictated by where did it go? Is because it is dictated by the existing legal principles. There you go. Operation of law. It's a legal term that indicates that a right or liability has been created for a party, irrespectively of the intent of that party, because it is dictated by existing legal principles. You got to understand the operation of law as it relates to property rights. The law followed the property, family. This is King Bam out. Man, I'm just telling y'all, keep listening to disingenuous information because they're not teaching you nothing. These people are not real litigators because they cannot break it down like I can break it down. So I'm out of here. Peace and love. Let's go. I'm out of here.